Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 179 of the NCDWI Guy podcast. On today's episode, we are talking about the hot off the press Court of Appeals decision, published decision of State versus Jacobs. This is COA 22-997. It's literally hot off the press. I believe it was published today. And so we're going to be talking through the court's opinion there. I think it's a very kind of far-reaching opinion for criminal defense lawyers. It would potentially have an impact in the arena specifically of DWI cases, but I think it has a kind of far-reaching effect. This case deals with the smell of marijuana, the smell specifically of unburned marijuana, of unburned cannabis. And so we are going to take a little bit of a kind of roundabout approach of looking at, where there are some holes, I think, in this opinion, where there are some issues that need to get brought out if you have a similarly situated case to present to the court, whether that's district, superior, or on appeal. And so we're going to dive into this. If you have a case that does involve marijuana impaired driving, which we're not going to get too deep into that today. Again, I think this could be a basis for a stop in a marijuana impaired driving investigation. But if you have a DWI specifically related to marijuana style case, go back and listen to episode 86. We talked about marijuana impaired driving specifically. In that episode, we did a pretty deep dive. I did a pretty deep dive into the National Highway Traffic Safety Administration's report to Congress on marijuana impaired driving, which I think is incredibly helpful if you have a marijuana impaired driving case. So go back and listen to episode 86 if you have a marijuana impaired driving case that you are looking to attack. But the facts of Jacobs are relatively simple and straightforward. This is a reasonable suspicion case. The defendant was challenging whether or not the fact that reasonable suspicion existed. In this case, the court said that the evidence tends to show the following. On March 29th, 2019, Officer Galuppi of the Wilmington Police Department was traveling in his patrol car on Market Street. Officer Galuppi turned onto Covell Avenue and noticed defendant's car traveling in front of him. He then gets behind the defendant's car. He travels behind him for approximately 50 feet when he says that he could very strongly smell the odor of marijuana emanating from the defendant's vehicle. So again, officer is sitting in his vehicle, defendant is sitting in his vehicle. They're both driving. And as they're driving down the street, Officer Galuppi says he can smell very strongly the odor of marijuana, which ultimately turns out to be the odor of unburned marijuana, or that's what he indicates was the odor of unburned marijuana. Officer Galuppi continues to follow the defendant for 5 or 6 blocks and eventually pulls the defendant over. According to the officer, he stopped the defendant solely because of the unburned marijuana smell. So that's the total basis for the stop, is basically the no traffic violations, no unusual activity or movements. Defendant was not in like a high crime area. This was not an unusual hour of the day. The sole basis for the stop was because of the unburned smell of, or the smell of unburned marijuana. The defendant is ultimately charged with possession of a cocktail of different impairing substances and challenges at the or not cocktail of impairing, cocktail of controlled substances. He's charged with possession of various substances. So the defendant challenges the stop based on a lack of reasonable suspicion. The court finds defendant specifically contends the arresting officer lacked reasonable suspicion to initiate the stop, as his claim of smelling unburned marijuana emanating from defendant's vehicle was inherently incredible. And then the court says, we disagree. So the court, the trial court found, nope, this is reasonable suspicion. Odor of unburned marijuana is reasonable suspicion. The Court of Appeals affirms that. And so on its face, basically this opinion says the odor of unburned marijuana is a valid basis for a stop. Now, what are we going to do today? We're going to talk about the science of cannabis for a few minutes. And I am no scientist by background. Science was not one of my strong points in at any point in my education. But I think it's really important as criminal defense lawyers that we really try to dig into the science. I think that science a lot of times can be on our side if we make the effort to get into it. And so this is a case, to me, this is a decision based on a poor understanding of science. So we're going to talk about science. We're going to talk here in just a second briefly about why this is such an important decision. And then we're going to talk about the SBI memo that has come out from the State Bureau of Investigation of North Carolina, which basically is very helpful for criminal defense lawyers on this front. So the way that I kind of like see this opinion is really, and again, it's hard to say exactly what the argument from counsel was at the trial court level or on appeal, but the court keeps mentioning that, basically defense counsel kept arguing that the smell of unburned marijuana was inherently incredible, not believable. The Court of Appeals does note that there was inconsistent officer testimony on this front. The officer at one point testifies that he thought that the back window of the defendant's vehicle was open as he was following behind him. Ultimately, defense counsel cross-examines him and shows on video that, in fact, the defendant's back window was not open. This is March. It's Wilmington, so it could have been a nice day in March. But I'm assuming that windows of everybody's vehicles, including the officers at first, were rolled up. So you can get the sense of this seems like a pretty crazy. Yeah, I mean, just a pretty crazy thing in terms of, this is, basically the officer in this case appears to have the nose of a drug dog is basically what it seems like in terms of the ability to detect marijuana in a separate vehicle. So again, I think that's part of what the court is wrestling with. But what the court doesn't appear to do is to kind of wrestle with why it's inherently incredible that the officer could note that it is this odor is marijuana, which is illegal, versus hemp, which is legal. And this is a distinction the court does not talk about. It does not address. The court's decision is primarily based on a prior ruling in State versus Stover, which is a North Carolina Court of Appeals case from 2009. The side on that is 200 NC App 506, 685 Southeastern 2nd, 127. State versus Stover appears to be kind of the main case that the Court of Appeals in Jacobs references. And again, it is very important that that case was decided in 2009 for reasons that we're going to get into here in just a second. So before I dive into the science, I kind of want to point out why this case is so critical. And it's really boils down to the fact that whenever you have an officer claiming an odor of marijuana, whether that is burned or unburned, it becomes really difficult on the defense end to attack that. And in this case, again, it appears defense counsel, at least in some level, was saying, the idea that the officer could smell the odor of unburned marijuana when these two individuals are in separate cars, they're outside, they're driving down the road for a very brief period of time, seemingly with windows rolled up, is just not believable. Ultimately, the reason why it's so hard to attack these odor cases is because it's kind of like, well, I guess the officer said he could smell odor, so he smelled an odor. Like, I mean, how do you attack that? There's no kind of physical evidence that you can present in the courtroom really to counteract that assertion by the officer. It's different than the officer saying, I saw this thing, because again, there are certain ways to attack eyewitness testimony, to attack, evidential, physical evidential testimony, but where it's based on this idea that I smelled the odor. What that really seems to allow the officer to do in many of these cases is to stop and investigate anybody that they say that they can smell that odor on. So it's very wide reaching and very difficult, generally speaking, on the defense end to attack an officer's smell. Again, for us here on this podcast, lawyers that primarily practice criminal defense, but kind of concentrate on or have a high volume of DWI cases, this could have far-reaching effects, because I do think that marijuana impaired driving cases are going to become more and more prominent as you see more and more people using THC, cannabis, marijuana. I mean, as you see this get used more, you're going to see more DWI cases that are based on this type of substance. So it has really far-reaching effect. There's a lot of stops that could be potentially based on smell. So Jacobs really could be, it's a published case. Again, it could be something that is very wide-reaching. So here's the issue with the decision, is that it really does not distinguish between something that the smell of something that is legal and the smell of something that is illegal. If marijuana had a smell that was distinct to itself and currently is illegal, it would make this ruling, at least to some extent, more scientifically validated. But let's dive into the science real quick. So what's the difference between marijuana and hemp? Well, the answer is, it's kind of a trick question, because there's really none. I mean, it's basically a technical difference, and not one of real meaningful distinction. So, again, let's get into the science for just a second. The word cannabis is used interchangeably with THC, quote unquote, marijuana strains. Cannabis is a plant genus. It's not a species of plant. It's a genus of plant. But marijuana and hemp are chromotypes, which is basically like a broad category for plants that are genetically similar but chemically distinct. Marijuana and hemp are chromotypes of this species, cannabis sativa L. sometimes just simply called cannabis sativa. But basically, marijuana and hemp are the same genus and species of plant. Same genus, same species, cannabis sativa. Now, again, there are several different chromotypes of cannabis sativa. I think that there's a total of 5. Hemp belongs to chromotype 3. I believe marijuana, as it's collectively referred to, is in the chromotype 1 and 2 category. And again, I think there's a 4th and 5th, which don't, kind of really have a high concentration of THC or CBD. But basically, it's, again, the same genus, same species of plants. Hemp and marijuana are simply sub-chemotypes. I think I said chromotypes, sub-chemotypes of the plant cannabis sativa. Now, why is that important? Well, the reason it's important is because this is the same plant. This is the same thing. What is the distinction between the two? It is one of legal distinction. So basically, for federally legal hemp, that is anything with less than 0.3% THC. That is the plant cannabis sativa, when grown, has 0.3%, less than 0.3% THC. I believe it's in its dried form. Yeah. So at bulk, in its dried form, has anything less than 0.3% THC is considered federal hemp. If it's above 0.3% THC, then it's considered marijuana. So again, this is really a word distinction. Hemp versus marijuana is really a word distinction. What are we talking about when we're talking about hemp? We're talking about cannabis sativa. What are we talking about when we talk about marijuana? We're talking about cannabis sativa. So what's the difference? It's really a difference of terms. Scientifically, it's in terms of scientific terminology, really there's almost no difference. It's, the different sub chemotype of the same plant, of the same species. But in terms of legal difference, now we use these words hemp and marijuana to distinguish the legal difference between these two. One that is a criminal to possess, and the other one that is legal to possess and to use and to smoke, to ingest, whatever it might be. Hemp, and all, as long as it's hemp, legal to consume, legal to possess, legal to smoke. And so what does law enforcement then use as a basis to distinguish between hemp and marijuana? How does law enforcement distinguish between these two? Well, all we have to do is look at the North Carolina's own State Bureau of Investigation memo on this issue, which you can find if you Google search SBI industrial hemp / CBD issues. Probably the number one result that's going to come up is a link by the School of Government to this particular memo. And so this is a memo from the State Bureau of Investigation. And what does it do? Well, after hemp became legalized federally, the SBI was tasked with kind of figuring out what are the legal implications of this. When, as this is going to be a crop that is going to be allowed under the North Carolina Department of Agriculture to be grown, what are some of the issues? And hemp is allowed to be grown, here in North Carolina. It's something that is legal to grow as long as you're, doing all the correct, you get whatever permits and licenses you have to have in order to grow. I don't know what that looks like, but it's legal to be grown, legal to be purchased, legal to be possessed, legal to be consumed. Hemp is legal. And again, it's really just termed hemp based on how much of a percent of THC there is in its dried form, that it's hemp versus marijuana. So what does the State Bureau of Investigation look at? Well, on page 2 of this memo, and again, if you haven't looked at this memo, go look it up. Here is what the SBI says. And again, what I think the court in Jacobs is missing. Again, I don't know if this was presented to the court or if this has been something that has been considered, but certainly if this gets appealed to the Supreme Court, which I believe that it should be, this would be something that I would hope that the Supreme Court would be able to consider. Here's what the SBI says. There is no easy way for law enforcement to distinguish between industrial hemp and marijuana. There is currently no field test which distinguishes the difference. This is critical for the Jacobs decision right here. Hemp and marijuana look the same and have the same odor, both burned and unburned. I'm going to repeat that. Hemp and marijuana look the same and have the same odor, both unburned and burned. This makes it impossible for law enforcement. And again, that's pretty strong language. This makes it impossible for law enforcement to use the appearance of marijuana or the odor of marijuana to develop probable cause for arrest, seizure of the item, or probable cause for a search warrant. In order for a law enforcement officer to seize an item, to have it analyzed, the officer must have probable cause that the item being seized is evidence of a crime. Further down, and I don't know if there is ability to distinguish at this point. I think that this memo came out in either 2015 or 2016. Certainly after both the federal legislation legalizing hemp and this memo came out after Stover. Okay, so that's an important distinction. Again, Jacobs relies very heavily in terms of the basis for the opinion on State versus Stover, which was decided in 2009. I believe that the federal law legalizing hemp came out in 2015, and I believe that this memo was issued in either 2015 or 2016. But whenever this memo was issued, 2015, 2016, the SBI says the North Carolina State Crime Laboratory does not conduct testing to differentiate between hemp and marijuana. I'm going to repeat that again. The North Carolina State Crime Laboratory does not conduct testing to differentiate between hemp and marijuana. The State Crime Lab, as well as most municipal crime labs in NC, perform a qualitative analysis on plant material to determine whether THC is present. All hemp and CBD products contain some level of THC. Therefore, the crime labs will report these products as containing marijuana or THC, which are both Schedule 6 controlled substances. While it has been suggested that additional funds be allocated to the crime lab in order to add additional chemists and equipment to conduct the qualitative analysis described above, this will not resolve the issue. As previously mentioned, law enforcement cannot seize an item without probable cause that the item is evidence of a crime. Not being able to distinguish between hemp and marijuana defeats the previous basis for probable cause to seize items believed to be marijuana. This memo is pretty damning. I mean, and I don't mean that pretty damning. It's pretty honest scientifically, but it's pretty damning to the idea that an officer can smell marijuana. An officer cannot smell marijuana. An officer cannot smell hemp. What an officer can smell is the plant. The officer can smell in unburned or burned form Cannabis sativa L. That's the genus and species of the plant. Now, unless this officer has some very highly trained nose that is able to detect subchemotypes of the same plant, which again, I can't find anything to indicate that there's an actual difference in smell. I would assume that there would be at least some level of difference of smell at like a very, I'm just laughing because it just, it would, it's somewhat absurd. Like, so I apologize for the laughing out loud, but again, the idea that an officer can smell marijuana, what they really mean is that they can smell cannabis. They can smell cannabis sativa L. And whether that cannabis sativa L is marijuana or THC is not going to be distinguishable, at least from anything that I can find, by the human nose. This is not going to be something that is going to be easily distinguished from a smell perspective. Science doesn't support that. Again, the SBI issuing this scientific memo says same odor, both burned and unburned. Law enforcement is not going to be able to use the odor of marijuana to develop probable cause for arrest. Why is that? Because there is no odor of marijuana. There's an odor of cannabis sativa L. So again, this is, I think, the scientific issue with the court's reasoning in Jacobs. Again, the Jacobs court, I think, has this decision has far-reaching impact. If you have a marijuana case, you're going to have to get into the science of this, I think, to kind of be successful and ultimately kind of get, the correct viewpoint of the court that you're arguing to across scientifically. You very well may need an expert witness that can come in. You could talk, who could you talk to? Well, maybe you get a grower of marijuana to come in and explain, or not a grower of marijuana, a grower of cannabis sativa to come in and speak to that. You can get, somebody from the North Carolina Department of Agriculture. You could get somebody from maybe the SBI. I mean, there's a number of different people that you could bring in to get this scientific point across. But basically, again, there's no ability to distinguish between the smell of something which is legal versus the smell of something which is illegal. And I think that's where this really falls apart on, and where this needs to be further litigated. So if you have a case where there is a stop based on the odor of marijuana, look at getting an expert witness involved in your case that can talk through the science of kind of the lack of real distinction between marijuana and hemp, that these are just kind of terms that we use legally to distinguish between a substance that can be legally possessed and one that is illegal to possess, but scientifically come from the same genus and species of plant. And then use that SBI memo. If your client can't afford to get an expert witness involved, or for whatever reason that's not available to you, use the SBI memo. You can attempt to get that in through, as a learned treatise. You could attempt to get that in as I'm trying to think of the word here, to attack the credibility of an officer that says there is a distinction in odor. So you could use that as a means of attacking credibility. And so these are the steps to take in order to litigate this issue. If you have a similar situation pop up where you have a stop that is based solely on the odor of marijuana, whether that is, the officer saying, I stopped the defendant based on an odor of marijuana, whether that odor is burned or unburned makes zero difference. So something to be on the lookout for if you have a similar case to the facts in Jacobs. And I look forward to speaking with you again next time.